Hi, everyone. We are just waiting on one more person. Oh, and there he is. Beautiful. Um, oh, and even a couple minutes early. Wonderful. Uh, that is perfect. So give me just 1 second to get everything ready. But in the meantime, everyone, welcome. This is the panel on unionization and workers' collective action. This is our penultimate panel and one that is going to be wonderful. I can assure you. So let me pull up the questions, but while I'm doing that, how about if we could just go around and the panelists could introduce themselves, say who you are and a little bit about what you do.
Do you want to call names or do you want us just to pipe in?
Go right ahead, Brian. You can start us off.
Thank you, Sarah. Good afternoon, everybody. Sarah, thank you for the opportunity to participate in the symposium. I'm Brian Aldies. I'm the Secretary, Treasurer, and Principal Officer of Teamsters Local 320. I am a 34-year Teamster, and I've been the Principal Officer of Local 320 for the past 12 years. My primary responsibility or responsibilities with the local union to its 11,000 public employees we represent statewide is as a fiduciary of the local union. And then second and third as the appointing authority. And I'm responsible for, directing and implementing the programs and representational needs of the locals membership.
Oh, wonderful. Professor Van Hoevelen, I saw that you were unmuted. Go right ahead.
Okay. Hi, everyone. My name is Tom Van Hoevelen. I'm an associate professor at the University of Minnesota in the Department of Sociology. I'm also affiliated with the Minnesota Population Center. My research interests are broadly in the causes and the consequences of economic inequality change, sort of over a long period of time. And a good bit of my research has focused on the contribution of unions and union power towards these long-run changes. Probably most relevant for this panel, some of my research recently has looked at how unions are consequential for poverty and for working poverty for both union and non-union households across American states. Some of my research has also looked at lifetime earnings premiums associated with union membership. And I'm really excited to be part of this panel. Thank you for organizing it.
I will just go randomly. Jackson, if you'd like to say a little bit about who you are, that would be great.
Sure. Can you hear me?
Loud and clear.
Great. Yeah, I'm Jackson Kerr. I work with Brian at Teamsters Local 320. My role is I'm an assistant business agent, meaning that I'm sort of frontline staff for working with our members at the University of Minnesota. So we'll get into that later, but some of the folks who represent at the U are custodians, dining workers, mechanics, gardeners, people like that. So I'm also a recent student at the U. I graduated from my undergrad in 2021. So I can't claim to be a student anymore, but I do still remember what it's like. So.
Thank you. Professor Block, I see you next on my list. How about you take it from there?
Sure. Hi, I'm Sharon Block. I'm a professor at Harvard Law School and the executive director of the newly renamed Center for Labor and a Just Economy, where we do a lot of thinking about labor law reform and other ways that the law can empower workers so that we can have a more just economy and democracy.
Wonderful, thank you. Trey, go right ahead and tell us about yourself and Setul.
Sure. Hi, I am Trey, and I am the ally organizer at Tool, Centro de Trabajadores, UNITA in Lucha. Yeah, I've been there for 5 months, and so we are a workers center instead of a union. And so my job there is to kind of build some community support for a building of worker power. And yeah, prior to this, I got out of Augsburg in 2022, and I've done some like youth and eco justice organizing in the past.
Wonderful. And then to wrap up introductions, Professor Garden, go right ahead.
Yeah. Hi, I'm Charlotte Garden. I teach labor and employment law at the University of Minnesota. And I'm interested in kind of the intersection of law and worker power. So, how labor law does and doesn't empower workers to improve their wages and working conditions, and also to kind of, participate in American democracy.
Wonderful. Thank you all so much. So I really appreciate you all being here. I thought that we could start off a little bit because our panel theme is punishing poverty and systemic poverty in general. And I was wondering if Professor Van Huvelen, your work looks at poverty and sort of measurements of poverty via data. How is poverty currently measured by the social sciences, and what do you think needs to be done differently to get a better picture of how systemic poverty and inequality impacts communities?
Oh yeah, sure. So there are a couple of different ways that you can measure poverty. So the traditional way that poverty is measured is the official poverty rate that was set sort of in sort of around the time of the war on poverty, sort of like the early 60s, and it is an unusual measurement. It was the official poverty measurement was developed by a research team, and their development they didn't intend it to be an official measure. Basically, they sort of found a sort of level of expenditure on food, and sort of looked at how much that expenditure was for for a typical family at the time, sort of expanded that out, and then that's kind of been sort of our benchmark for poverty. I would say that most poverty scholars these days use something called a relative poverty measure, especially if you want to make sort of comparisons across countries, or sort of and that would be something like taking half of sort of the median income of a country at any point in time, and if you're below that, you are considered poor, and if you're above it, you're not. So there, I think typically, if you do it in that way, you typically, more folks, or at least, in recent decades, would be considered to be living in poverty. I guess the project that brought me to this panel was a collaboration with David Brady, who's out at the University of California, Riverside. And we were interested in how sort of union membership, both sort of at the household level and sort of union density at the state level. So, are there more or less sort of union workers in your state in your particular year? How does that contribute to sort of risks of poverty? And we found a great longitudinal data set that has really high quality income measures on the panel study of income dynamics, which tracks individuals from one year to the next over a long period of time. It's been running since the late 1960s. And we found a couple of things. One, having a union member in your household was highly predictive of poverty rates, right? It was very protective against the risk of poverty. But two, having having sort of like robust, strong unions in your state had broader protective measures. So both unionized households and non-unionized households in states with strong and robust union memberships had sort of lower risks of falling into poverty. And why is that? Well, because we know that unions do a lot of things beyond just immediate bargaining. Unions organize sort of folks who are marginally attached to the political process. Unions sort of work to sort of get sort of more egalitarian policymakers elected and sort of pressure them to pass and enforce egalitarian policies. And these have a lot of sort of downstream benefits for a household's overall income. So, the effects of unionization at sort of the state level are sort of similarly sized to a bunch of other things that we think matter for poverty, things like economic growth, for example. And so, what we found and we our publication sort of shows that, unionization sort of both immediately but more broadly are very important for predicting poverty.
Wonderful, thank you. Yeah, that's a great find. Absolutely. I encountered your paper, which is how I encountered you, and it was very interesting to see. And I think that's sort of a great lead in to my question for Brian and Jackson, which is the Local 320 was very involved in the negotiation and labor efforts for the University of Minnesota's dining services employees. And I understand that they nearly went on strike, but reached an agreement. And I was hoping that you could tell us a little about that campaign and sort of in seeing the immediate and long-term effects of workers collectively advocating and having a union to advocate on their behalf to fight economic conditions that keep them in poverty.
I'll dive in first. I'm going to just sort of give a little bit of a historical background to our campaign at the University of Minnesota. And then what I want to do is let Jackson dive into the specifics because Jackson really quarterbacked that initiative this last time. Teamsters Local 320 has represented the University of Minnesota service workers for decades. We have a history of reaching voluntary settlements without much incident with the University of Minnesota. The service workers that we represent, they not just work in dining services, as Sarah mentioned, for example, but they're in the dorms and all throughout the University of Minnesota campuses, providing mechanical work, HVAC work, janitorial cleaning services. They remove and haul trash, recycling, and the list goes on, probably about 60 different classifications across the University of Minnesota campuses. We started organizing, really organizing the members to affect some change in bargaining about 6 years ago, knowing that it's going to take a handful of years to organize the troops to a point where they're ready to strike the University of Minnesota. The University of Minnesota has a long history of, sort of perpetuating poverty in the communities that the University of Minnesota campus, the campuses are located in. And, I think it was Professor Van Hoevelen that, talked about measuring or the systemic and impacts of poverty, but it doesn't just affect these workers in their checkbooks, but it's their ability to raise their families and participate in their families' events and provide better environments for their children. Our workforce has become more diverse over the course of time. We've conducted economic impact studies at the University of Minnesota, taking our work, our members' incomes, benefits, and what the impact is to the communities that they live in, generating tax dollars at both the local, state, and all the state and federal levels, as well as what the impact is to local businesses, banks, retailers, grocery stores, how do they spend their money and things like that. So what we learned is the University of Minnesota is really a terrible actor in these communities in terms of perpetuating poverty and keeping people down, especially the marginalized populations that work at the University of Minnesota. So we engaged our International Unions Strategic Initiatives Department and worked with them to put together a campaign. We really needed to engage our membership, educate the membership, but we also needed to engage and educate the communities that the campuses are located in and get involved in a political campaign. Throughout this process, we had the opportunity to meet Jackson and some of the other organizations that are involved, with the University of Minnesota, student organizations, graduate organizations, and as well as the teachers at the University of Minnesota too. And so, there's no better force than organized labor. For those of you that study this and get involved in education, know that it's true. An individual's voice may not be heard, but 1,500 voices will, from an 11,000 member local union and a 1.4 million member international union. So, that's a little bit of history. We went at this starting about 6 years ago to solve these problems, knowing that it was going to take some time, because of the work that we had cut out for us. But some things that we learned along the way, some of the things that we did with this campaign, I think I want to let Jackson dive into this, but I also want to say before I do that this was one of the most rewarding experiences that I've been involved with. Having the opportunity to work with so many different populations at the University of Minnesota campuses, but also to, all the hugs and tears that were shared because of how we were able to lift people up through this process. So Jackson, why don't you get into a little bit more of the specifics and the details of the question?
Sure, yeah. I'll try not to belabor some of the points Brian's made, but I think maybe to get into specifics. So, the professor was talking about measuring poverty in the United States. And it's true that, having union members present in the household, that undoubtedly has a positive impact in raising people out of poverty and contributing just to, a workforce that's treated better and has time for itself outside of work. That being said, I think it's also worth mentioning that I think especially in recent years, we've really seen employers become more aggressive, not only like in how they treat their workers, but also in their lobbying at the state, federal level. And generally we've sort of seen an offensive from the employers in this country. And I'm sure other people on this panel can speak to that as well. And that's, the University of Minnesota is no exception. And like Brian was saying, this university, it claims to be a force for good in the community, and it's a public institution, but in reality, especially I think since the early 2000s, we've really seen this university take an aggressive bent in bargaining and just how it treats its workforce. So just to share some statistics, we did a survey of our membership going into bargaining, and we found that 62% of the respondents who were current or former Teamster members at the U did not earn enough money to pay for basic expenses every month. 12% reported experiencing homelessness at least one time while working at the university. And close to 20% reported being hungry, not able to eat sometimes because they didn't have enough food, or enough money for food rather. So that really tells you how this university treats its workforce, even a workforce that is protected by a bargaining agreement and a labor union. So that's really what we were coming up against. I think one other thing I want to mention that Brian was sort of alluding to is the demographics of the workforce at this university are increasingly immigrant labor and immigrants from East Africa. So when we're talking about a struggle at the university, there's definitely, I'd say, a racial dimension to how the university treats those employees. And there's also a global dimension to the struggle, right? Because when we're bargaining for employees who work at the university who are immigrants, a large share of that money is actually going back home to Ethiopia and Somalia. So when we're bargaining wage increases, not only is the impact felt locally and statewide, it's actually felt internationally when people are sending money back home to folks in their home countries. And I'm sure the panelist from SATOOL could talk about his work with immigrant workers there. But that's just another dimension I wanted to add. So we did come very close to striking. We did a lot of community solidarity work, and we did a lot of actions on campus, which we could talk more about. But the net result was we got a huge wage increase for a lot of these members, effectively pulling a lot of them out of poverty. So an example is the starting rate at the university has jumped now from $15 an hour to $20 an hour. So that's a $5 wage increase for a lot of our members. And, you know, that's life-changing money for a lot of people. And that really does illustrate the power of a union. Just that one anecdote, I think, is, you know, the fact that workers can come together and get that, you know, that really does illustrate the power of the union. Just one other point I do want to raise is, you know, I think the economic effects of this agreement we just reached will be widely felt, but I think there's also a psychological dimension to a campaign like this as well. And, you know, the University of Minnesota, there's a couple major unions on campus, but there's a lot of workers on campus, including undergraduates, graduate students, faculty who don't have the protection of a union. And I think for them to witness this and to actually participate in the campaign itself, that has a psychological boost for the entire campus that will be felt for a long time. And I really do hope that not only are Teamster members benefiting from this agreement, but the entire university campus will, in the mere fact that it provides empowerment and sort of inspires people to fight for their own unions and their own betterment. So we could share more, I'm sure, but there's a lot of ground to cover with these other panelists. So I'll stop there.
Well, thank you both. I really appreciate it, and I appreciate the work that you did. It was I was in Professor Garden's labor law class while this was throughout the news, so it was very interesting to see what was going on and then be able to talk about it, which sort of leads into my next question for Professor Garden, which is sort of what have you seen in terms of, you know, what is the policy rationale that drives labor law generally, and how has that changed to sort of disenfranchise workers individually and collectively and sort of give employers the chance to be more aggressive, like Jackson was talking about?
Yeah, great. Yeah, thank you. So let me sort of start by saying I'm going to talk about the National Labor Relations Act here, right? The federal law that covers most private sector workers rather than Minnesota state law, which is what covers employees at the University of Minnesota. So if you read the National Labor Relations Act, which, you know, everyone should do, the original 1935 language, it is unabashedly pro-unionization, pro-collective bargaining. It was written to respond to oppressive working conditions that harmed workers individually and also harmed the economy as a whole. And it was meant to empower workers to come together and kind of use their collective leverage to claw back from employers a greater share of the economic gains that their labor helps create. And, you know, as panelists have already been talking about, collective bargaining works. It worked then, it still works. Unionized workers make more money than their non-union counterparts. That's especially true for workers of color. Unionization doesn't make the racial wage gap disappear, but it shrinks it. Unionized workers have other protections too, or usually do, like a contractual right not to be disciplined or fired without cause. But today, right, well under 10%, something like 6 or 7% of private sector workers are unionized. And so if we think about, you know, evaluating the National Labor Relations Act according to its own stated policy, right, its own goal, right, we would probably have to say that it has failed. And so I think there are a lot of reasons for that, more than, you know, we have time to get into today. But maybe I'll just sort of highlight that labor law envisions that organizing and bargaining will take place on the enterprise level, at the workplace level. So, you know, one group of employees and their employer. Labor law makes it harder for workers to organize across an industry or even across several employer locations, right? So we're seeing that like with the Starbucks campaign now. So employees are organizing on a store-by-store basis, and that makes perfect sense. You know, it's hard enough to build the trust that you need to unionize and overcome employer opposition on a store-by-store basis. It'd be like virtually impossible to organize all the Starbucks workers in one city or one state, you know, sort of all at once. But then, you know, when it comes to bargaining a contract, it's like incredibly difficult to get Starbucks to, you know, an employer that's dead set, right, against its workers organizing and dead set against reaching a collective bargaining agreement with them. It's very difficult to get Starbucks to actually come to the table and bargain with a union that represents a single store. So that's in part a function of weak labor law, and I'm guessing that Sharon will talk more about that. And it's in part a function of kind of Starbucks' just lack of kind of economic incentive to reach an agreement. But there's no kind of cosmic law, right, that says that organizing and bargaining have to take place that way among individual groups of workers, right? We could have a labor law that leaves it up to workers rather than up to employers to have the choice about whether to aggregate for purposes of bargaining. So that's sort of one example, but there are lots more about how labor law impedes effective worker solidarity, right? We could point to what David Weil calls workplace fissuring, which is what happens when large companies disclaim responsibility for working conditions by contracting out parts of their operations. We could point to misclassification of employees as independent contractors, which takes them outside of labor law. We could point to things like the National Labor Relations Act's prohibition on some forms of what's called secondary activities, so like sympathy strikes. So, you know, we can, if you think of labor law as kind of creating a playing field, in many ways, it's not an even playing field, right? It's a playing field that makes it much easier for employers to oppose unions, oppose both unionization and then effective collective bargaining, right? Than for employees to actually unionize and bargain a contract like the Act originally envisioned they would.
Great, thank you so much. And I think that leads very well into the questions I had for Professor Block, who has a lot of experience working on labor policy in both the Obama and the Biden administrations. And I wanted to ask you, Professor, just understanding that this is where labor law is currently, how the act is playing, the National Labor Relations Act is playing out. What policy changes do you think need to happen? What on the ground work needs to happen to expand workers' rights and unrestrict the people who benefit from collective action.
Great, thank you. So labor policy in terms of supporting and maximizing the potential that the NLRA provides for workers to be able to unionize resides in the National Labor Relations Board. And so I would actually say this administration did the most important thing that they could do in that respect by appointing an amazing general counsel of the National Labor Relations Board who is really committed to living up to as much as possible that spirit and mission of the act that Charlotte just referred to. So in terms of what the Biden administration can do in this front, I think that's probably the absolute key thing, in addition to just being a president who is very proud of referring to himself as the most pro-union president in a long time. But, you know, there's really not that much aside from appointing the right people to the NLRB that the administration can do to change these dynamics that Charlotte was talking about. That's really a legislative fix that we need to have. So the PRO Act, the Protect the Right to Organizing Act, has been pending in Congress for a long time. I don't think I'm saying anything that everybody doesn't already know, which is that it's not going to pass in this Congress. It did pass the House in the last Congress, couldn't get through the Senate because you need 60 votes in the Senate, and it's clearly not going to pass again in this House. So in terms of giving more workers the right tools to be able to organize, it's really a matter of actually organizing at this point. Unfortunately, though, even those opportunities are limited because of exclusions that are built into the National Labor Relations Act, which sadly have as their origins concessions that were made to racist and sexist senators and congressmen when the law was originally passed. And so those are exclusions for domestic workers and agricultural workers who just don't have any rights to organize as the law stands now. Because those exclusions, even with that sorrowful origin, they still exist today. The other place, though, where we're seeing a lot of workers excluded from the ability to organize is in the category of independent contractors, which that exclusion came into the NLRA a little bit later, but is having a bigger and bigger impact today, in part because there are sort of the gigification of our economy. There are workers who are independent contractors, truly independent contractors, who maybe could benefit from the right to collective bargaining. But more importantly, because of this exclusion, you have employers who are misclassifying their employees. That is, treating them as independent contractors, even when they really are employees. And this is a place where you see a lot of activity around litigation and legislation at the state level around trying to require these employers to treat workers who are not independent contractors, who are really employees, to treat them as employees. There was a big fight, as people may know, in California over how to classify Uber drivers, Lyft drivers, other rideshare drivers, or whatever we're supposed to call them now. That has never sat completely right with me. And, you know, so the California legislature tried to make clearer that these employees are actually employees for purpose of labor standards, maybe as a predicate to then creating collective bargaining rights for them. But the industry came roaring back with a ballot initiative that unfortunately passed in California, and the status then of that, where that all stands, is actually also subject to litigation. Here in Massachusetts, we've got a couple of different bills that have been introduced again in the same way to try to make clearer that more people who work, who are subject to sort of the economic domination of an employer, should have the right to collective bargaining and should have the protection of basic labor standards. So that's been a big part of this debate over who should have the right to collective bargaining. How can more workers exercise more power? There are other exclusions from the act, like effectively for undocumented workers. They're technically covered by the National Labor Relations Act, and so have a right to engage in collective bargaining. But the Supreme Court said years ago that they can't get a remedy if they're treated unfairly because of their bargaining. So it's kind of like a right without a remedy isn't really worth very much. So that's sort of the big picture of why we've got so many, even as hard as it is for workers who are covered by the act to exercise these rights, there's this whole other universe of workers who don't even get a right to give it a try.
Absolutely. Yeah, and I'd like to focus on a point that you made about independent contractors and how that's a significant problem, is this misclassification and this sort of loophole for employers to call their employees independent contractors. And I want to throw it to Trey to talk a little bit about the independent contractor problem, especially for Seytoul and what you have seen with this issue of workers being called independent contractors and what they experience.
Totally, yeah. Yeah, I can give a bit of background context here. Seytoul is doing some organizing with non-union construction workers. So we're talking about kind of like roofers, painters, scaffolders, all of these kind of unlicensed trades, and also often these people are Central and South American immigrants, and so yeah, in terms of coming here, often end up kind of like here for a job, or often even trafficked here, being promised housing, food and health and healthcare, and then often those promises aren't followed through, and then often they are kind of hit kind of with this option of not working as an employee of these subcontractors on bigger building projects, out of a sense of kind of the kind of American dream, small business owner kind of a deal, but then also it opens up the chance for these subcontractors to basically kind of legally get off without covering things kind of like a workers' comp or kind of other pieces like that. And also, kind of the general problem in construction is that's kind of how the entire industry is built. Because I jumped onto this campaign in October, and so getting here, I was kind of thinking about these kind of building projects, and I'm like, okay, you have these developers, and then a couple of contractors. Well, kind of how it turns out is you have a developer, a general contractor, and then you have about like 20 or 25 subs, and then even each kind of a contractor might even contract out a part of their job. And so kind of this kind of big decentralized kind of a way of building these projects opens up a ton of opportunity for labor abuses, because everything is kind of kept from being held accountable to these developers and general contractors by generally about kind of like three to four layers of subcontractors. And so in kind of the case of our construction campaign, this system is pretty good for the developers, because they can ask for projects to get done faster, which often means worse working conditions and other kinds of abuses. But then legally they kind of can't be held accountable for that. So
Yeah, absolutely. Thank you. Yeah, it's a huge issue, I know. And, you know, as Professor Black said, the gig economy, if as some people have called it that, so Uber drivers, Lyft drivers, other sort of app-based work, calling their employees independent contractors, has caused a lot of problems, that it is beneficial to employers at the disadvantage of employees. I'd like to ask Professor Van Hoevelen briefly, some of your work has to do with right to work laws as well. And I was hoping that you could talk a little bit about what right to work laws are and how they impact collective worker action and unionization and things like that.
Yeah, sure. We'll just if we're talking about non-standard work, and contingent work, one just if I could follow up on that, one thing that I think is kind of neat is that we can compare different country contexts, and we can see that our system isn't the only inevitable one. Like as we were talking about that, like I was thinking, there's there's this article that came out a few years ago by a few folks at the Labor and Employment College in the University of Toronto, Gomez and Lamb, and they looked at union coverage in Canada of non-standard workers, and generally being covered by a union was really beneficial for non-standard workers in the Canadian context. So if we think we can, so there's no reason to think that certain types of work are just fundamentally unable to be covered or protected by some form of unionism, and we can kind of look at the cross-national context for that. Okay, so that's just one point. Another point, right to work laws. Yeah, so these are laws that were sort of allowed by sort of the late 1940s pushback against the Wagner Act. That sort of opened up a bunch of for all the issues and problems, that opened up a bunch of possibilities for union power. Right to work laws are state level laws that remove union security agreements. So basically removing the condition of union membership or dues as a condition of employment at a certain firm. So the United States has a highly fragmented bargaining system, right? So we were talking about sort of Starbucks and sort of negotiation at this particular location versus location, right? So that's a fragmented system if you compare sort of like across a bunch of different rich, affluent, rich democracies, and what right to work laws do is that they further fragment that fragmented system by sort of removing that sort of firm level sort of buy-in from workers. And some work that I have done, some work that has been done by other social scientists show that these laws are quite effective when they're passed in sort of times and places that where unions are strong. The fragmentation works. I find that it increases inequality. A few political scientists have shown that right to work laws reduce union power and reduce union sort of contribution to the political process, that it reduces voting among sort of more marginalized groups. Some of my work shows that right to work laws are associated with sort of more aggressive pushback against labor. And so, it sort of opens the door to sort of fragment an already fragmented sort of bargaining system. And given that we know that unions are really important for things like political integration, earnings, inequality, it's the outcomes sort of follow unsurprisingly.
Yeah, absolutely. Thank you. That sort of pulling from the thread of the issue of independent contractors and misclassification and gig workers, app working. I want to ask Brian and Jackson, sort of from the perspective of unions and formal union organizations, what has been the response to this, or what has been your experiences with employers saying, well, no, this is an independent contractor, we don't have to bargain, we don't have to negotiate or anything like that?
So, as I mentioned earlier, we solely represent public employees in Minnesota. So we don't necessarily run into issues with independent contractors, let's say like Lyft, Uber, or FedEx, for example. So it'd be difficult for us to comment on that.
Yeah, of course. Go right ahead. Yeah.
I could just, it's sort of relevant in the sense of
the university.
Yeah, the U. So one issue we're seeing at the university right now, and I think this is sort of emblematic of sort of trends elsewhere in the economy, sort of like others are saying, but the university is attempting to outsource a lot of its work to non-union employees. And that looks different depending on where you are at the university. So I think the best example I could give maybe is our dining services. So like I mentioned, starting in the early 2000s, the university sort of started to take a more aggressive approach to how it treated its workforce and the unions on campus. And one of the steps it took, sort of in this direction is it outsourced the management of dining on campus. So all of the residential halls that have dining facilities and all of the retail dining on campus is actually not managed by the university. It's managed by a third party. And right now that third party is called Chartwell's Company, which is actually a subsidiary of a much larger company called Compass Group, which is based out of the United Kingdom. So you get this strange scenario where there's a company in the United Kingdom that is running dining at this, university in the middle of Minnesota. And that causes problems because the management obviously could care less about the workforce there, given that it's a outside company. And another thing we've been seeing from Chartwell's, this company, is that they're attempting to bring in temps and outside workers, and claiming that they don't fall under the bargaining agreement. So an example is and then the lead up to our strike, they were flying in chefs from around the country to work in the kitchens. They're called Chefs on the Fly. They have their own agency, but the company was paying for their hotel and they were paying them wages that were far above what the union represented employees were making. Yet the union represented employees were being asked to train these people on how to do their job, basically, and how to, work in these kitchens. So we're currently fighting with the university to get rid of these temp workers or to force them to join the union. But I mean, it's a good example of the loopholes and the sort of the ways that employers try to sort of edge out the existing union workforce in a certain location. So I hope that sort of answers your question.
Yes, it does. Yeah, I think that's a very important point. And what I was going for is the outsourcing and the attempt to work around organized labor. In the same vein, or in a similar vein, I was hoping Professor Garden, there was a court decision, Glacier Northwest versus Teamsters. I was wondering if you could share how that impacted some of the tools that unions use for bargaining power and how it made it more difficult to strike.
Yeah, sure. So this is a case that's pending in the Supreme Court. They've heard oral argument. There's not a decision yet, called Glacier Northwest v. Teamsters. And so the case arose out of a strike among a group of unionized drivers who drove concrete mixing trucks. And they called the strike in order to put pressure on the company because they were in bargaining. So trying to pressure the company to agree to a new collective bargaining agreement. So the union calls the strike among this group of 85 drivers. And the strike happened to be called at a time when concrete had been mixed and loaded onto 16 trucks. Some of them were out making deliveries. So it turns out mixed concrete doesn't last forever. So for example, if the drivers had said, oh, there's a strike, turn the car off, or turn the truck off, leave it on the side of the road, the concrete would have immediately started to harden and that would have destroyed the trucks. But that's not what the workers did. Instead, they returned the trucks to the employer and they left the drums rotating. So that protects the trucks. The company hadn't made any provisions for what it would do in the event of a strike. And so what it ended up doing was kind of disposing of the concrete. And then later on, the company issues like these disciplinary letters to 16 drivers. And also, and here's kind of the key part, it sues the union in state court in Washington. And it's seeking damages related to like the lost concrete and the disposal. So the Washington Supreme Court said, not so fast. This case is controlled by federal law, not state law. And that's because these were a group of workers who were striking. Their conduct was at least potentially protected by the National Labor Relations Act. And then confirming that view, afterwards, the National Labor Relations Board, through its office in Washington, issued an unfair labor practice complaint saying that the issuance of the disciplinary letters violated the NLRA. So the Washington State Supreme Court decision is what went up to the Supreme Court. And there are kind of three big issues here. One is kind of a technical issue, but an important one. It has to do with what's called the NLRB's primary jurisdiction. And that means that the NLRB gets first crack at deciding labor law issues, right? So the NLRB gets to be the body that first tries to figure out or decides whether this activity was protected by labor law. And then the second issue is related. It has to do with when federal law displaces potentially contrary state law. You might think about this as being a question about how much kind of breathing room unions have when workers strike or take other collective action. So usually if the NLRB decides that a strike loses the protection of labor law because of how the workers carried out the strike, that can lead to bad consequences, right? Like the workers could be disciplined or fired, and that wouldn't violate labor law. But what could also happen, depending on what the Supreme Court does in this case, is that could still happen, but then also the employer could sue the labor union, right? And sort of try to, sue it out of existence, right? And then the last question here is the scope of the right to strike. So on one hand, the right to strike has always included the right to strike at an inopportune moment for the employer, right? So imagine you've got a union of accountants. If they are going to go on strike, they're going to go on strike on April 14th and not April 16th for obvious reasons. If you're the employer, right, and it's mid-March, you're going to be aware, right, that you're vulnerable, right? You're especially vulnerable right now. And so you're going to try hard to reach an agreement, or you're going to make arrangements to cover the work using supervisors. You're going to use the tools that are available to you in the labor market. But you're not going to say, well, if my accountants strike on April 14th, I'm going to go to court and try to get the union to pay for all my lost business. On the other hand, there are a couple of NLRB decisions out there that have to do with strikes that are timed not just to cause the employer to suffer economic harm, but also to do a lot of damage to kind of life and limb. So think about a strike that's called just as a load of molten metal has been, poured. And if the strike is called right at that second and everybody just walks out of the building, the entire plant could burn down. So in situations like that, the NLRB has said, that those strikes aren't protected, and they've framed that in terms of the obligation to take kind of reasonable precautions to safeguard lives and property. So that reasonable precaution standard, that's been applied in situations where it's like the plant might burn down, but not situations where the danger is that the employer will lose the value associated with just a perishable product. So the employer is arguing that should be expanded here, right? That strikers should have to take reasonable precautions to protect not just the plant, but also the perishable product. So it is not great news for labor that the Supreme Court decided to hear this case, right? The Supreme Court, I will say, has been hostile to organized labor for much of its history. And that is definitely true of the Roberts Court. So, I would say if you were placing bets on how this case is going to come out, you should bet that the union will lose. The harder question is how, right? What will the Supreme Court say in its decision? And that will have a lot to, that will, have effects, right, on the scope of the right to strike. The court might narrow the right to strike, right, by saying, by expanding this kind of reasonable precaution standard. It might do something like make it easier for employers to file lawsuits against unions rather than settling contracts or dealing with strikes by just kind of resorting to their own economic weapons. There's one more potentially kind of interesting possibility, which is that the court might cut back on the scope of what's called labor preemption in a way that would open up more room for states to pass their own laws affecting the ability of workers to strike effectively. And certainly some states would do that in a way that would make it harder to strike, but you could also imagine whether there might be room for state laws that would make it easier for workers to strike. I wouldn't say I think it's tremendously likely that the court will do that, right? I think the more likely outcome is that the court will write the decision in a way that only hurts unions. But, at the same time, right, it's worth sort of, I think now is a good time for states with, especially states that have like democratic trifectas, to be thinking about, okay, how might this go and how might we respond? Including sort of narrow statutes that might kind of say, okay, we're not opening up our kind of tort remedies, right? We're not opening up our state courts to lawsuits that employers bring when they lose just perishable products because of just normal strikes. So there's a lot of kind of uncertainty here. It sort of depends what the court says. We'll get the decision sometime before June, probably in the next kind of couple of months. And then we'll have to kind of think through, right, or labor and state legislatures will have to think through, what it means for the scope of the meaningful right to strike.
Thank you. Yeah. I think that is sort of an example of just like how complicated labor law has become and how difficult it has become for workers to rely on labor law for success and for an even playing field, like you mentioned earlier, which leads me to Professor Block. You're very involved in the Clean Slate for Worker Power project, and I was hoping that you could tell us a little bit about what that is and what the ideas behind it are, and what does the future of labor law look like for that project?
Thank you. And I just want to give credit. Professor Garden was a very key member of our team that worked on Clean Slate. So Clean Slate for Worker Power project is a project that we housed here at what's now called the Center for Labor and a Just Economy. And the idea was, like, labor law is so broken that a lot of benefit could come from fixing some of the problems that we've known have been sort of, that have come into the act over the years. And that has been a project of labor law reform in the Congress for a while. But our sort of diagnosis of the problem is that it's actually bigger than what you can fix by adjusting the mechanisms that the NLRA created for building worker power. And that what was needed was like a real rethink of what are the best ways to enable workers to build power. And so we brought together an amazing array of people, like I said, including Charlotte, but over the course of about a year, we had hundreds of people who came to convenings that we held, that participated in different ways, that put an incredible amount of work into thinking about, if you had a clean slate, if you were starting not from no institutions or the unions, but from a legal clean slate, what structures would you build to enable workers to truly be capable of demanding the kind of economy and democracy that they want. And so through this process, we came up with a series of recommendations, which we released in January of 2020, shortly before the whole world shut down. And some of those key recommendations have to do with addressing a lot of the problems that you've heard discussed throughout this panel. Starting with expanding the options for the ways that workers can act collectively. Like the way it works now, even before you get to the problems of enterprise-based bargaining versus industry-based bargaining, everything in our system is a winner take all. Like if workers want to organize and they can get 50% plus one in their workplace to agree, they get a union with the full panoply of rights that comes with that, putting aside like how useful those rights are. If they get 50% minus one, they get nothing. Almost really, the law protects almost no structural power building tools, no right to bargain. So that's one piece of thinking about what are different ways that workers can come together and act collectively. But then at the heart of the recommendations too was this idea to allow workers to move bargaining to the level of the sector. So having workplace-based bargaining, because there are a lot of things that are idiosyncratic to your own workplace, but in terms of where the real power building is, to allow workers to engage in what's called sectoral bargaining, which is actually the way that much of the rest of the world does collective bargaining. So that's having workers, representatives of workers from across the sector, be that fast food or auto manufacturing, or, I mean, that's one of the tricky questions is how do you define these sectors, but assuming you can do that, sit across a bargaining table with representatives of employers from across the sector. One important thing that does is it takes wages out of competition. So right now, employers, one reason why they fight unionization so hard is a perception. I'm not saying it's a reality, but a perception that having a unionized workforce puts them at a disadvantage vis-a-vis the other companies in their sector. If you set wages and basic work conditions across the whole sector, so now employers aren't encouraged to compete by racing to the bottom, but they're forced to compete on things like how productive are their workers, which is often connected to how well can they recruit and retain workers, how well do they manage their business, how good is their product. So that's a key part of our clean slate recommendations. Having a more inclusive law so that the workers that we talked about at the beginning of this panel are not excluded from the law. Expanding what workers can bargain over. The law as it stands now creates very tight guardrails around what workers can bargain over, assuming that workers really only care about things like money and time off, but not about the impact, say, on the environment that their company has, even though that's clearly implicates how workers feel about their jobs. It was like 100-page reports. We have lots of things, but just to mention a couple of others, we think it's really important that workers have greater ability to get involved in democracy. So more like time off to be able to use it to be involved in politics, and then to allow innovation at the state and local level. So some of this, what Charlotte was just talking about, the way that the Glacier case presents the downside of state innovation, but what we recommended is to opening up space for state at state and local level for there to be innovative policies around empowering workers that go above and beyond what the federal labor law would do. So those recommendations came out in 2020. We issued a COVID specific report in May 2020 of like how these ideas could play out in giving workers a voice in working conditions designed to adapt to the pandemic. We gave out a series of grants in 2021 to groups operating at the state and local level in ways that were empowering of workers, doing interesting and innovative organizing. And now we are planning the next steps in Clean Slate. And one place where we hope to be very active is in helping to think about how the law can respond to the Supreme Court's decision in Glacier, because like Charlotte, I'm not overly optimistic about what that decision is going to hold for the labor movement.
Thank you. Yeah, that's wonderful. And I encourage everyone to check out the Clean Slate project. It's very interesting, very great work. With the couple of minutes that we have left here, I encourage anyone to drop a question in the Q&A if they have one. But I have one last question that I'd like to ask of Brian and Jackson and Trey. In your experience in working to organize workers and create a movement of labor organization, it is often that you encounter, especially for employees, it can be sort of frightening to stand up to your employer or to even discuss standing up to or asking for better employment conditions or asking for better wages. And oftentimes I know that people might not even know what their rights are as employees. So I would ask you, sort of, when it comes to getting people to take action and to, realize, I do have power, I do have, if we work together, a change can be made for our collective benefit. What, in your experience, is the most helpful thing for people to know about their rights as employees and collective action? So we can start with Brian.
Wow. Okay. Well, and I think this goes back to the conversation that was just had and some of the comments that Sharon Block had made about the strike and what we risk in this current court case. It's these types of circumstances that we find ourselves having to find more creative ways other than the strike, for example, to put pressure on employers and decision makers for the outcome that we're looking for in our contract negotiations. So to the question, the campaign that we recently had at the University of Minnesota, and then we also had a campaign with our 2 bargaining units that we represent with the State Board of Public Defense, and finding those creative ways and running those campaigns. Workers who are unorganized and workers who are organized who have not exercised their rights or used their collective power, it gives them, they see what rights they have. They see what opportunities they have when they operate in a collective way. We had an organizing campaign about 9 months ago here in South Washington Public Schools, where we organized 500 workers, and they had been with another union, but they had never been shown what rights they have or given the opportunity to exercise their collective voice. They saw what happened at the University of Minnesota. They saw what happened with the State of Minnesota Board of Public Defense, and they were there. Therefore, they were ready to organize with a union that knew how to use its collective power.
Yeah, just to follow up, I think, I mean, it certainly can be like very intimidating, and I don't want to speak for people who are in that position necessarily, because, as somebody who works for the union staff, it's a little bit different experience for me. But I will say, I mean, one thing I have noticed, and I think we're seeing this nationally, is um, at a certain point, you don't really have a choice. Like, I think we're seeing, I mean, when you're entering conditions of such brutal poverty and such a dire economic situation, we haven't really discussed the inflation rate right now in this country, and it is going down, but for working people, that's like a huge, the price of eggs and milk. I mean, this is all very basic stuff, and at a certain point, you don't really have a choice. Like, you do have to organize simply to maintain your standard of life. And I think we're seeing that across the spectrum. One of the really encouraging things, I think, is the Starbucks organizing that we're seeing. A lot of that is being led by college graduates, actually, people who have college degrees, but who are so saddled with debt and who are entering a labor market that just frankly doesn't really care if they have a degree or not. Though when you're forced in that sort of situation, you sort of faced with the question of how do I want to live the rest of my life. And I think for a lot of people, they're deciding that, um, life is too important not to organize a union or to push back in some way. So it's not a direct answer, but that's just sort of my take on things right now. So
Yeah, thank you. Yeah, I'm thinking a lot about it, kind of like C-Tool. Most of our organizing work is very kind of like a relational, and often it just kind of boils down to a ton of one-to-ones, and also in terms of kind of like this intimidation factor is, when it comes to talking to these these bosses and kind of like stuff, is that kind of like we can't go with the workers to talk directly to the boss. And so that kind of causes, I wouldn't say a problem on our end, but more of a difficulty of getting past kind of that intimidation factor. And so often we talk a ton about like agitational one-to-ones, thinking kind of about how each kind of worker in our org is like often talking to kind of like one or two ground organizers. And so kind of the first thing to kind of like build off there is that sense of trust, because we're asking them to take a pretty big risk often. And so yeah, often in these kind of like agitations, you're kind of sitting down and trying to figure out what is the obstacle kind of stopping this person to take action. And often that kind of obstacle can be anything. It can be kind of like things from child care, like worried about losing pay, physical and even sexual abuse. And so kind of like these are these general kind of like obstacles. And so part of our job as organizers is figuring out how to just get past that, to kind of get past that obstacle. And so often kind of like something that often kind of like is kind of like used in kind of like these agitations when talking about fear is kind of like calling back to past acts of leadership by these workers. My boss often talks about how during our campaign, when we were talking to people in fast food, this was like circa 2016, he was talking to a cashier, and she kind of like was talking a ton about being afraid to talk being afraid to talk to her boss, because it's kind of like she hasn't ever done anything kind of like before, but she had talked to him off and on for 4 months. And so my boss asks, well, it took a ton of courage and leadership to enter into this country by crossing the Rio Grande. And so linking people's past chances at courage and leadership. I think helping them figure out that all of those past times to sort of practice these things isn't any different from when we walk on to our bosses. And so yeah, I think we can talk about talk about all of these kind of a policy kind of like ways to kind of get there. But I think at the kind of end of the day, in terms of action, you just have to kind of build up trust and hope and faith, not only in the labor movement and in their particular struggle, but also just in themselves too. So
Wonderful, thank you. And I think that's a great point to end this panel on. And I thank you, all of our panelists, and Professor Van Hoevelen, who had to go a little bit early. But I thank you all so much for being here and being a part of this panel and having this really wonderful discussion. And I encourage everyone to learn about your rights as workers and employees wherever you are. And if there are any employers in the audience, learn those rights as well. Um, but I think we're all employees here. And, you know, thank you so much for all the work that you do, and thank you all for being here. And for our attendees, our next panel starts in just under 8 minutes. We will have our final panel on housing justice. So I hope that you are all able to stay for that panel. And thank you all for coming today. I really appreciate it.
Bye, everybody. Sarah, thank you for the invitation.
Thank you very much. I appreciate it.
Yeah, Sarah, thanks. I'll see you soon.